Good morning. Today I will be discussing the current state of medical liability in Australia and particularly Queensland from the perspective of Australia's low-income demographic, encompassing regional and remote as well as Indigenous areas. We see that the current legislation is not adequately equipped to handle negligence that results in the unnecessary suffering of patients. Among these patients, we see at-risk groups from low socioeconomic or Indigenous backgrounds face further struggles in receiving compensation due to inherent structural disadvantages and financial instability. This presentation will seek to obtain a broad analysis of the state of medical liability within Australia, whilst focusing on the structural issues present in the legislation that can seek to hinder justice for those that have been harmed. Points of contention within the current structure of the legislation surround exorbitant fees and financial disincentive, a lack of information flow from practitioners to patients, and a reactive healthcare system that seeks to learn from the mistakes of its past instead of seeking best practice when moving forward. These factors inherently inhibit the ability of Australia's low-income demographics to receive medical liability compensation and, in general, access their healthcare. Before we delve further into the need for reform, a brief summary on why the law is in place is needed for us to better understand this growing problem. Early negligence law was developed to ensure reasonable care will be taken to avoid injury. Within the medical field, a particular importance is placed upon a health practitioner's recognised duty of care within clinical relationships. This is essentially to combat quack doctors providing unfit services under the guise of medicine. The landmark decision in the 1992 case, Rogers and Whittaker, provided the principle upon which medical liability law developed, highlighting the need to disclose risks associated with procedures, despite their remoteness. This brought more transparency to the medical industry and facilitated a stronger flow of information from practitioner to patient. Rogers showed the need for patient knowledge of material risks, wherein if a patient attaches significance to a risk, the medical practitioner is obliged to let them know of it. Rejected within Rogers and Whittaker, but codified within the Civil Liability Act under Section 22, is the Bolam test, which negates a practitioner's negligence if it is found that they acted in their professional duties in a manner that is widely accepted by peer professional opinion and could be considered competent. This will provide the basis for a later analysis on this law. The current state of medical negligence liability provides a long and arduous journey for patients seeking compensation. This is unsatisfactory in a country that touts universal healthcare whilst inhibiting access to those subsects of society less fortunate. A recent Grattan Institute report highlights that 1 in 9 Australian patients experience complications during their hospital stay, with this figure jumping to 1 in 4 when staying overnight, for a grand total of roughly 725,000 people admitted for complications every year. This highlights the need for medical liability processes to be secure and accessible to all members of society, as the prevalence of complication is high. For those who face financial difficulties, particularly in Indigenous and remote communities, the current structure of the legislation is geared towards deterring negligence claims through administrative tasks and financial burden. This is largely due to out-of-pocket expenses and the need for specialist reports in order for your case to be viable pursuant to the Personal Injuries Proceedings Act, or the PIPA. These PIPA requirements seek to ensure that medical practitioners are not unjustly targeted and there is an adequate evidentiary burden a claimant must first reach before pursuing damages. Unfortunately, the relevant purpose of the law does not reflect its action in all circumstances, due to both the financial burden this places upon poorer demographics and the difficulties that arise in acquiring compliant reports. The long road to compensation can be quite literal due to the efforts associated with acquiring an independent medical report from a specialist that is credible and accurate. These difficulties are exacerbated in regional, remote and Indigenous communities where income per capita is below average and access to healthcare is limited already. These people then have to travel to neighbouring states and such and then have to file more paperwork because of their interstate reports. The Grattan Institute report highlights that it does not take much for individuals to opt out or delay care due to the associated financial burden of healthcare, with statistics highlighting between 2016 and 2017 that 540,000 people did not see a specialist or delayed doing so, 9,704 people who needed prescribed medication reported not purchasing their prescription or delaying their purchase, and 662,000 people delayed or didn't see a GP when needing care. These statistics highlight a looming problem within Australia to avoid healthcare due to the inherent financial burden, and when looked at within the scope of this analysis, we see that the requirement for expert reports would likely have a similar effect of delaying or halting the legal process for claimants due to cost. If they're already not going to get healthcare due to the price, it's very hard to then justify going through the litigation process to receive the damages that you owe from your current burden of bodily harm or injury that you've suffered as a result of the negligence. Further inhibiting justiciable outcomes is the relevance of Section 22 of the CLA that states, "A professional does not breach a duty arising from the provision of a professional service if it is established that the professional acted in a way that at the time the service was provided was widely accepted by peer professional opinion by a significant number of respected practitioners in the field as competent professional practice." The subjectivity of peer opinions and subsequent confusion surrounding what is widely accepted as medical practice creates subpar outcomes in court scenarios very regularly due to the application of the S22 of the CLA as a defence. This is seen in the recent case of South Western Sydney Local Health District in Gould, where an initial successful claim of negligence was overturned on appeal due to the appellant judge rejecting notions of irrationality in the professional peer statements. This was due to the opposing opinions of medical experts as to whether or not the antibiotic regime was fit for purpose or fit for the person. The trial judge's primary notions of fairness were seen as skewed within the realm of professional opinion due to the revelation that the antibiotics, although not being ideal for the child, adhered to guidelines and therefore were rationally administered. This is a terrible outcome for this family and anecdotally hints at the systematic processes available to medical practitioners to combat negligence claims, whilst claimants can be very simply rebutted if a practice is widely accepted. After understanding why the laws surrounding medical liability for negligence were created and how they now operate within a modern context, it can be seen that there is an unintentional divide between health sector services and ideal health outcomes for patients. The administrative process alone in attaining specialist reports before somebody can make their claim, although present to protect practitioners from improper litigation, instead has the effect of also boxing out lower income patients within the public healthcare system. This deterrent measure, whether intentional or not, highlights a procedural issue that requires reform. The implication of this deterrent policy is that in remote areas with limited access to healthcare, an issue of negligence would likely result in a reduced medical liability to the practitioner responsible, as well as more difficulties for those individuals to be brought to justice due to the distance between specialists who can create reports. Access to the requisite facilities required to take legal action and offer legal aid would provide areas of regional Australia, and particularly Queensland where the PIPA Act is enforced, with justiciable social outcomes. This, coupled with a law that does not look at each individual negligence case upon its own merits, but instead in line with the ever-changing medical practice, makes it difficult for claimants to receive compensation. A 2011 report of the Productivity Commission on Disability and Aged Care highlights that a no-fault system could be the solution to compensation reform. The report highlights this as necessary as the current indemnity system surrounding negligence is slow, inefficient, and not very cost-effective. To make matters worse, it adds unnecessary stress to those already in the grips of poor health. It becomes increasingly clear the further Queensland's medical liability laws are examined, the further away justice seems from those without the financial resources to traverse the mammoth uphill battle that is a successful negligence claim against a practitioner. Some of these problems include, but are not limited to, the expert witness participation, where it's very hard to get specialists to testify against other specialists because of the community. There's administrative efficiencies that we've noticed in the specialist report that's required. There's over-the-top litigation expenses for the government as well as the individuals, which will likely box them out of any equity for their situation. The complexity of the evidence and the evidentiary burden that's required also adds to the strain of the whole process. And finally, the precedent that is regularly upheld through the Civil Liability Act, that as long as it is widely accepted as practice, doctors have no obligation to err on the side of caution nor liability for wrongdoing if they acted according to what is simply accepted. This notion takes away from individualistic ideals of patient care and hinders health objectives for patients. Reform is necessary to provide those that are negligently affected by the healthcare system a form of compensation without first needing to remortgage their home. Thank you for listening. Thank you for attending this information session today with the Queensland Legal Support Network. Please forward any inquiries regarding issues that resonated with you today to the email seen above on screen. Thank you for listening.